The Indian Contract Act of 1872 has several important cases that have shaped contract law in India. Here are 5 significant ones. First one being Mohri Bibi vs. Dharmodas Ghosh, 1903. This case is pivotal in contract law as it established the principle of voidable contracts due to the incompetence of one party, especially minors. The Privy Council ruled that contracts entered into by minors are voidable at the option of the minor. Second one is Carlyle vs. Carbolic Smoke Ball Company, 1893. Though not an Indian case, it is widely studied in Indian contract law. It dealt with the concept of unilateral contracts and held that an advertisement can constitute a valid offer and acceptance by performance, like using the smoke ball, creates a binding contract. Third, Bhagwandas Govardhandas Kedia vs. Messrs. Girdharilal Parshottamdas, 1966. This case highlighted the doctrine of privity of contract, stating that only parties to a contract can enforce its terms. It clarified that a stranger to a contract cannot sue unless the contract was entered for his or her benefit. Fourth important one being Dharmaratnakra Rai Bahadur Arcot Narayanswamy Mudaliar Chattram vs. Bhaskar Krishna, 1933. This case is notable for defining the concept of impossibility of performance as a valid defense in contract law. It held that if a contract becomes impossible to perform due to circumstances beyond the control of the parties, it can be void. And the fifth important is Satyavrata Ghosh vs. Mugniram Bangur and Company, 1954. This case dealt with the doctrine of frustration. It established that if a contract becomes impossible to perform or radically different from what was initially intended, due to an unforeseen event or change in circumstances, it may be discharged due to frustration. These cases represent landmark judgments that have significantly influenced the development and interpretation of contract law under the Indian Contract Act of 1872. Thank you all.